It's high time to open the space for a potential discussion. Therefore, if you have any questions, notices, please do not hesitate to do it.
Hello, and ladies and gentlemen, my name is Bartłomiej Ręczek, and I'm from the Ukraine in Poland, and it's a bit obviously I have a question to date. I'm very happy that your interpretation of EU law is such in this way of interpretation, because we will have a lot of the discussion as always. But I would like to ask you about your opinion, not regarding the discrimination, because you said something about the current justice of the European activities, the judgment activities according to the discrimination, and maybe I can agree with that the interpretation is one and is against of all member states, that there is no way of discrimination. Okay, but what is your opinion to the equality principle? Not the discrimination, but to the equality principle in the EU treaties as to the Court of Justice of the European Union. My question based on that we all know that principle of equality defined in Article 4 is not only the principle of equality of member states, but this is also the general principle of equality, consisting of elements like protection of the state functions, diversity of member states, and the protection of the heritage, cultural heritage, constitutional diversity. So, what is your opinion regarding, in my opinion, extensive activities of the Court of Justice of the European Union, sometimes in the literature called a competence creep, like in my opinion it was in Polish and Hungarian cases, and the like of equality, the principle of equality, not only the equality of member states, but that this principle defined in Article 4, with elements from that article like protection of the state functions, and so the activities of the court it's a little bit famous cases, like the Polish one that you referred to, the Share one. It is the line with the principle of conferral of the competences, for example, and the Court of Justice are, in your opinion, just a cog or the super arbiter regarding to the interpretation of EU law, and this is not only, as I said, equality of member states, but also equality as protection of state functions. So thank you very much.
So thank you for this very interesting question, and I absolutely agree, and this is even how I teach it in my lectures. I agree with Professor Biac that the problem here which we have is of a different qualification. The Court of Justice says that Polish courts are courts of the European Union, and thus because they enforce the EU law, and thus they should be subordinated to certain principles given by the EU law and formulated by the Court of Justice, and that's the basis for its action. On the contrary, Poland says, well, there is nothing in the Hungarian treaties that allows the European Union to regulate the system of justice in member states, the judicial institutions. That's a matter of full competence of Poland, and we have done what we need to do, and for what we have done, strong mandate from our people. So it's a roll-up of a different qualification. And you mentioned also the principle of concurrence. So according to which the European Union, they act only within the limits of powers which are conferred to the United States. But I believe the principle of concurrence unfortunately does not apply in what it is Court of Justice, as this court as equals to decide what belongs into its competencies within the limits of primary law, and that's the core of the problem. Since this court was entrusted by the possibility to interpret it in a binding way, its main tools reference for preliminary rulings, and they results prove that since decisions are binding. This gave the Court of Justice the power to interpret the law in a uniform way, and there are quite strong arguments based on the need to secure the equality through privacy and equal and uniform application in the whole European Union that are in favor of the argumentation of the Court of Justice. Hence, the biggest counter here is that we know it, member states know it, they know it for over 60 years, and they haven't done anything about that. So as long as we are in a position that we have to somehow follow what the Court of Justice says. On the other hand, I fully believe, and I've written several articles, that national constitutional courts do have the power to interpret the constitution and say it's constitutional according to European constitutional law. And the problem is that this is, the data they have. And they have to be very careful to use it, since sometimes it may lead to a situation which is not, which cannot be, which might not be possible solved by the tools of law within the European Union. And I think that the Polish Constitutional Court was simply to open it when addressing certain issues. My personal opinion is that sometimes it is better to remain silent and do whatever you need to do through internal decision making, and not to, tell the truth or things that are too loud in a binding decisions. And I think that here Polish Constitutional Court unfortunately crossed the line.
Okay, so thank you very much. Only one that I can add to your answer is that I also agree with that the constitutional courts of member states should, and not the should is maybe not a good word, they have a power to interpret their constitutions according to the line of the cultural, social, law heritage, and it could be against the law. So in this line, and in one of the chapters published by Central European Academy, I argued that they should be like the watchdogs of the Court of Justice of the European Union, but I also agree with the statement that the Court of Justice of the European Union, with this institution we have a great problem according to the principle of non-part, because it should apply, but in practice is not applying to them.
Well, the aspect by my personal opinion is that these courts, and this applicable to constitutional courts as well as the Court of Justice, that they should apply a set of approach which is self-restrictive. Yeah. And I think that here both the Court of Justice and well, not in the Polish case, but earlier it was Portuguese case concerning salaries of judges. There was the first side where this resolution the Court of Justice crossed this thin border, and I think that this has been done by the Polish Constitutional Court too. Sorry for that.
So thank you very much.
Dear colleagues, so we have arrived at the next part of our conference, of the section 2, that is the discussion. And all three presentations included some very inspiring and wide insights on very different topics, starting from migration and judicial cooperation in criminal matters to human rights and into EU law. And I strongly encourage you and invite you to comment on all three presentations and or to ask questions to our presenters.
Thank you so much. My question is to Professor Lestovici, and the question is connected to the convention and the Constitutional Court of Croatia. I try to understand the situation, and let me start it with the Hungarian practice, if I'm correct. There are numerous cases where the Hungarian Constitutional Court has a similar practice as to the interpretation of given legal rights as in the practice of the European Court of Human Rights. But as I said, sometimes they have different approach. But what is the situation in this case with the Constitutional Court practice of Croatia? Because notice that it's enchantment, that was the last word. Therefore, there is no difference between the approach, for example, of human rights between the practice of the Croatian Constitutional Court and the European Constitutional Court.
If the European Court in Strasbourg takes a stand on the point, then the Croatian Constitutional Court starts suit in every single case, without exception, without thinking about. So, every time the European Court in Strasbourg changes its practice, we follow suit according to him.
Thank you so much. That's another question to you. There was a Hungarian professor and he was also a judge of Hungarian Constitutional Court, which categorized the different constitutional court practices. And the basis of this categorization was that whether the practice of the European Constitutional Court it is more emphasized, or the text of the Constitution itself. And in other words, we understand because there were some constitutional courts which always started their reasoning and interpretation referring to the text of the Constitution, and they stick to the text of the Constitution. And there were other constitutional courts which never referred to the constitutional text, but they referred only in the practice that even case, they're even case law. And there are different categories, and of course between these two different ends, there are of course not necessarily constitutional courts. Even if you found this potential categorization, how could you determine the operation of the Croatian Constitutional Court?
Well, in this regard, I can say that a constitutional court at the European Court of Croatia usually invokes the text of the constitution, but relies heavily on the practice of the European Court in Strasbourg. So they were precedent that the court uses the convention and the practice of the court of Strasbourg, even when there is ample practice of its own practice and the provisions of the constitution, and that there is no need in reality to use the convention and the practice of the Strasbourg court, but the constitutional court does it anyway.
It was really interesting for me because as to this categorization of hierarchy that it was prepared by a Hungarian professor at Justice, the Constitutional Court of Croatia was at the one end. Only the text is questioned, the constitutional text, they stuck to the constitutional text, and the practice it was not as emphasized, but it's really interesting that the convention is a kind of exception, if I correctly understood your answer. Thank you so much.
I would that as a moderator, I also have the right to ask a question, and I will use my right. And I have a question also to Professor Staničić, also about the peer convention and the enchantment. By the way, I like very much these two perspectives from the point of view of all the, let's say, the approach of Croatia towards the Yugoslav Convention, and the other approach is non-adjustment and resettlement towards the EU. So that's something very interesting for me. I have a bit aware that it was so different in relation to these two frameworks. My question is that whether this enchantment that, as I understood, began in 1990s when Croatia was joining the Council of Europe and the ICHR framework. So it was then in 1990, but has it remained? And also after these, let's say, 20 years, is it still like enchantment, or maybe some other approaches or emotions have emerged?
I would say that enchantment still remains, and in a period of time, the court of Strasbourg was seen by the public as a savior, as an ultimate goal and ultimate means to have your rights respected. And that will, in my opinion, create a reflex of the Constitutional Court, which, when delivering its decision, always try to anticipate what would Strasbourg say on the matter. We just had one argumentation on Wednesday when I was the judge that gives the summary of judgment, and I was for the declining, and one of the judges in my chamber asked what if the Strasbourg would to read his complaint in another manner, with even though the plaintiff did not stipulate that given constitutional right was violated, they could perhaps read it as it was violated, and then they would rule that his right was violated. But it was very, I was confused, because I said, why would we anticipate that the court would rule differently? And why does it matter? If it would rule differently, then it would, and then we would probably change our practice. But why shouldn't we decide how we think we should decide, without primarily concerning ourselves what Luxembourg will say? So that is the reflex on the Constitutional Court, which always, I would say, fears that the Strasbourg would think that we stray from the line, so to say.
Thank you. And I have a question to Professor Wies and Dr. Rangel. How about Poland? Do you think in Poland a poet was also enchanted by the European Convention and the Strasbourg Court, and whether we can find similar approaches also in Poland, like in Croatia?
I think that both of because politics is specialized to European law, like all the criminal analysis and that victims and a lot of law disease cases.
Okay, I'm on time. Okay, it's okay. I think that the question is about the impact of the European Convention in Poland. That is the impact of the understanding the law.
I was referring more to this approach or sentiments described by Professor Stančić when the European Convention and the euro was, let's say, adopted in Croatia, that towards the European Convention there was so much positive, let's say, approach, enchantment, as Professor Stančić referred to, while towards the EU law there was rather resentment, so negative emotions. And I was wondering how it was in Poland.
Now?
Because it's a different situation,
as I can say that now that the perspective of the Polish authorities, bodies, courts, and tribunals are as very positive. I think that is like accepting everything on behalf of from the convention, and for example, some times ago, one of the very high Polish officers said that the case of from Strasbourg or Luxembourg should be treated like sources of law in the time when the Polish constitution do not refer to the judgments as sources of law. So that is now the situation in Poland, I think, according to the interpretation of the convention. And it was not the case before it was 15 December. Before that, we respect I would say sorry, but I always try to be honest. We respected the rule of law. Now it's a situation that public bodies make some actions, for example, based on the lawyer's opinion, that as in constitution we have sources of law only, that the laws, constitution, orders, of course international law, but law on the judgments. And there is now the opinion of lawyers, for example, and this opinion of lawyers said, for example, sometimes ago that the case law of the Court of European Human Rights, Court of Justice of the European Union should be treated like a source of law, without any constitutional basis. And when for example, Polish Constitutional Tribunal say that this is not appropriate and put interpretation, some officers, public officers said that this is not a tribunal. So now this is the very strange and how to say hard situation in Poland, and I think that now the convention or the other international laws are treated like higher distinction of the national laws. I thought maybe Professor would like to add something.
Professor Aniszek powiedział, sorry, that was a question of Katarzyna Zombori. For me, the question how the present constitutional tribunal approaches, for example, the convention, not only the other institution, government, parliament, other things, but the constitutional tribunal itself.
So the Constitutional Tribunal itself is based on the interpretation that the Polish constitution is the most important, that the last ruling according to EU law, but it was according to the EU law, not to the convention, okay, but it referred to the principles of the sources of law and the hierarchy of laws. So for the Polish constitution, for the Polish Constitutional Tribunal, the Polish constitution is the most important. But the problem is that, as I said, that there is some opinions that Polish Constitutional Tribunal from some time operating not as a constitutional tribunal based on the constitution, Polish constitution. As we all know this opinions, and for example, I personally not agree with this, but this is not the topic of this conference. I'm sorry, but through the prism of the cases of law of the Polish Constitutional Tribunal, it is obvious that from the current state of the development arc of the judgments is that the Polish Constitution is the most important, more important than rather than from the convention, European Convention, but also from the EU law. And there is the interpretation according that the Constitution is the most important. But if there is the option to make such an interpretation of this Polish Constitution that is in accordance with the convention, this interpretation will be in favor, because it's in the line. But if it is possible, not from the logic point of view, the tribunal, it was in a 26 or 2007, such a ruling issued by the Polish Constitution that if there are provisions of the Polish constitutions that are not in the line of the international law, we should look for the interpretation of the Polish Constitution in line with the Polish with the international regulations. But the line is the logic and the content of this law. That if we can find some solution that to connect to these regulations, it is okay. But if not, the Polish Constitution is first. Yeah. And from the perspective of the time, the Polish Constitutional Tribunal doesn't change this approach. But before the changes of the government, there was one more ruling but it was according to EU, not the convention.
Thank you. If I may, it is also somehow connected to the question of monism and dualism, of how different national legal orders, let's say, regulate the relation between domestic law and international law. As I understood, the Croatia has opted for the monist solution. Poland is more with this dualist approach, so that also has, I guess, some influence. Dear colleagues, and I have Professor Zechland.
Well, I don't have a question, just a comparison I took at the perspective of the Czech Constitutional Court. And since we have several new judges since last year, I'm not familiar with their activities yet, so I will refer to the verdict of Constitutional Court until 2024. And the situation was similar to Croatia, but the approach was not unitary. I mean, every chamber of the Constitutional Court had its own unique approach how to work with case law of the European Court of Human Rights. Some chambers were inclined to cite decisions of this court and use it as a parallel argumentation, legal argumentation to justify the decisions together with previous decisions of the Constitutional Court and with argumentation based on our Constitution, whereas some chambers were quite reluctant to use the case law of the European Court of Human Rights and relied more on our own Constitution and previous case law of this court. Generally, I can say that the tendency to use law in the same way was lower. In most cases, only those chambers who were actively working and citing the case law of the European Court of Human Rights were also willing to argue based on a European Union law. And within the EU law, we have to write order in the European Charter, where the Constitutional Court is quite apt to use it, and the rest of the law, which is not seen as something, relevant for our Constitutional Court.
First of all, a comment. The Professor Radovan presentation referred that some Hungarians they the Bible about cars in Slovakia. Yeah, it's absolutely true. In Hungary, we have a specific phrase to these Hungarians who bought their cars in Slovakia. They are plate numbers Slovakians. We are this car. We reference to them. And I have a version, the Professor Simon, you use the phrase that regional constitutionalism, but what does it mean?
I just used the term as a question. So what I meant by regional constitutionalism, something maybe on the point where the it by some people can be considered to follow the road too. So this is just a question when we can, if we can transpose the principles of international law in such constitutionalism, or I mean within the founding treaties, then they develop more on the way to the constitution. So that was just that point of thinking and consideration.
Well, I wanted to ask exactly, no, but I thought the turn, I got your second question. So there was a perfect posture, and being much more of a public discussion, also what would be your answer then? You passed the question for us, so may I ask the same question, the second one, should international institutes be implementing the general constitutionalism? But there is some question. I'm just repeating the question, what's it? Because you phrased it like should.
I would say should, but with some modifications, not very. Because,
Really?
because the principle of international law, not our principles. So, not all principles of international law are automatically transposed into the law in middle order. So also this principle, it can be, but there are many limitations within the founding treaties. So if you follow the conditions stated in the Vienna Convention, then it is very difficult to fulfill these conditions. But of course, the base of the principle can be transposed.
So that the question is not alone whether they should, but if they meet the requirements set up by public international law, that's definitely not, then they meet the requirements.
Another stakeholder is the transfer of competencies. As I said, there are some theories, many transfer of competencies with the EU, so that it cannot be invoked by the members within these competencies that they're already transferred.
Beautiful public international law and EU law, because that's the question. These are the theories, whether you really, as a sovereign, whether you transfer sovereignty as such, or just manifestation that I've pointed out in the comparative case. Because how has been the EU created? By what are the primary sources? That's my question about the constitution. So that I'm saying that that's just theoretical transfer of manifestation of sovereignty as such.
And the
Yes, I had it up in there. Okay.
Sovereign states could freely use the level 6 antibus principles in current situations.
The article situation now Russia, Ukraine.
Russia-Ukraine about the previous situation with the Poland relations to EU. For example, about the judgments of the European Court of Human Rights, and that is all, of course. Everybody can say this is pacta sunt servanda. That's because we agreed for that. But there is rebus substantivus also.
Sure. This is general treaty law, international treaty law, and as it has been said, the ICJ Gatchukova case has really, I think, it affect research into that principle. and these require us to be at on a very high threshold. Nevertheless, there is the possibility. The question is that whether the state actually wants to, because that's why I asked to be more particular. If you look at Russia, what Russia has chosen to do, you've got different types of international organizations. They decide to stay with the Security Council because they've got special positions, so they want to still be a member of the UN.
Of course.
So council here, what holds the decisions of the court are legal body. And they cannot influence it that much. And from the procedure point here, they decide to, there was the possibility. If you look at the security, in English it's obviously, there's the anarchy of the procedure, how to get to a conclusion or the position of the organization. So they actually choose different ways depending on different procedure aspects of their membership giving organizations. Whether it is applicable, yes. The general principle practice, and also this that this is so complicated. The requirements are so complicated that there are other ways how states can achieve their goal. So you actually see cherry picking, I would say.
Yeah, this is. I agree that my states use the principle of the rebus sic stantibus sic situation is like an opt-out situation. Because if they would like to be a part of the international law organizations, they do not can just use the rebus sic stantibus because this is like a go through the door. That is the case. So the conclusion in my view is that states can, but it is not the question. It's not the question. It's about the consequences.
The question is what they actually want. And there's a like choose of this example because you perfectly see.
You know, this microphone is very small and yes.
You can perfectly see how those really wonderful clinical circumstances perfectly sound on oppression. And it's cherry again the rights how particular
What the Közép-európai?
For example, just comparison these two, you are in the first.
Okay, thank you.